Qualified executive privilege. Nixon argues that absolute privilege is necessary to preserve candid advice of those speaking with the president. Privileges exist because there are interests that are more important than the truth. Nixon ends up getting a qualified privilege protecting communications. Qualified privilege might not work in other situations. In-camera review sufficient where judge can review and eliminate irrelevant documents and info. Nixon's request is too broad, he would have privilege over anything he did in office. Should court take into consideration the reaction of the public and the consequences? Court may look as if they are in Nixon's pockets. If court gives president absolute executive privilege, unsure impeachment would happen. Constitutional vs. common law. Unclear if this is a constitutional or common law claim. Ruling based on executive privilege and separation of powers. Nixon v. GSA. Facts: Nixon made agreement with GSA saying he would be the only one with access to his papers and documents from his time in office, but Congress passed law requiring Nixon turn over his stuff. Justifications for Congress passing this law. Many trials still going on, and therefore access to evidence was still required. Future presidents need access to fully understand foreign affairs, military, etc. History is important. Transparency. Problematic issues with Nixon keeping papers and tapes B/C he had exclusive control and he would likely destroy. Recognized that these are the presidents to give, takings case. But, past presidents have given their documents. Court doesn't have to decide on this issue B/C if they take documents, Nixon would likely get paid. Additionally, Nixon should have had reasonable expectation that papers would have published B/C behavior of past presidents. Who can assert this privilege? Current president, national security. Past presidents, personal matters. Screening would happen first. Separation of powers. Court doesn't buy this argument. Both Ford and Carter supported this law, therefore. Youngstown-Jackson 1, President and Congress agree. Not a bar B/C co-equal branches are not hermetically sealed off. This will not interfere with the legitimate powers of the President. Nixon argues job should not be assigned to a lesser person in the executive branch, the archivist. Executive branch control is better than the legislative branch. No reason to think archivists will leak or disclose classified information B/C they have never done so in the past. Current regulations are not final and therefore the court will not decide on them now B/C the issue is not ripe. Nixon had absolute right to review any documents before they were released. Test, rather, in determining whether the act disrupts the proper balance between the coordinate branches, the proper inquiry focuses on the extent to which it prevents the executive branch from accomplishing its constitutionally assigned functions. Only where the potential for disruption is present must we then determine whether that impact is justified by an overriding need to promote objectives within the constitutional authority of Congress. Dissent, Rehnquist. Rehnquist argues this case is like Youngstown. But this can be distinguished from Youngstown because here a private citizen challenging law rather than an executive order, and therefore they differ substantially under Jackson's analysis B/C Congress and executive branch are acting in unison here. Bill of Attainder. Taking of papers and documents constitutes punishment which is directed only at Nixon. Separation of powers issues. Congress acting as legislature, executive, in enforcing, and judiciary, sentencing. Due process issue. Nixon being singled out. Congressional trial. Compared to due process issues in, Walter, Nixon. Court holds this is not a bill of attainder. Nixon wasn't singled out B/C this applied to all former presidents. Not a penalty B/C he gets compensated. Important public policy purposes. Nixon v. Fitzgerald. Facts: Fitzgerald lost his job at the Air Force due to reorganization. Requested relief. Plaintiffs in Youngstown requested relief was an injunction. Here, the relief was for monetary damages, President would be paying out of pocket. Money damages is clearly different from injunctive relief. Why should the court protect the President from this requested relief? We don't want President to worry about being financially liable for official duties or responsibility, don't want him to think about this when making decisions. Majority, absolute immunity from suits based on actions taken in official capacity, not in Constitution, but sensible. Dissent, okay with qualified immunity. Clinton v. Jones. Facts, Jones brings civil suit stemming from actions of Clinton that occurred before he became president and don't relate to official duties. Clinton requested stay of trial. Holding, no stay of trial B/C. The issues at hand in the suit don't relate to official responsibilities and official duties of presidential office. Dismissal on pleadings and summary judgment will eliminate frivolous litigation. Allowing case to proceed won't undermine President's ability to function. V. Congress and the legislative process. Whitman v. American Trucking Associations. Facts, Clean Air Act give EPA Administrator the power to promulgate and revise the national air quality standards. EPA is interpreting the statute and setting governing standards that states have to comply with. Penalty if states do not comply, sort of like. Similar to laws Congress could pass itself. Identifies who is covered. Holding. Rationale. How much control should administrative agencies, AAS, have? Administrative agencies should surely have the ability to make procedural rules. Should they be able to do more though? EX create speed limits for national parks. Where do we draw the line here? Congress delegated this authority to the EPA because EPA has access to information. Complicated process, CFR and notices on proposed regulations. Whereas Congress would only have hearing. EPA has expertise. Technical. Variable. EPA required to review, Congress probably couldn't review. Would be difficult for Congress to deal with all of the different AAS. Policy issues. Statute is not just technical, EPA is making discretionary policy decisions. People of goodwill could come to different answers. In comparison to Youngstown. As a matter of policy, Congress believed the executive branch shouldn't be able to act here. Here, Congress is delegating policy discretion to executive branch, just not the branch. Here we're in Jackson's first category. This can't be the end. Congress should not be allowed to delegate all of their power. Why should Congress be the body making policy determinations? They are elected and accountable to their constituents. EPA employees are not. Congress can't waive its ability to legislate. Intelligible principle. Court creates limits on what Congress can delegate to AAS. Not the case here that Congress is trying to get rid of its responsibilities. Giving EPA direction as to what it wants the agency to do. Hasn't put down the numbers, but what more could Congress have reasonably done without actually providing the numbers? Difficult to know what else. Standard has to be defended in court. Court has only found 2 statutes that Congress had surpassed non-delegation precedents since 1935. Mistretta v. United States, PG 373 majority opinion, Scalia dissent relevant here. Death of delegation? Court issued cert to hear delegation case this spring. Immigration and Naturalization Service v. Chadha. History and background. At the time Congress had to pass specific bills allowing people to stay in the country despite the laws requiring them to be deported. These private bills were subject to corruption and unfairness. They delegated the power to rule on exceptions to Attorney General and other AAS and provided standards for them to rule on. But these decisions were all subject to congressional review, legislative veto. Review all determinations allowing people to stay in the U.S. for additional time after they should have been deported. Either House of Congress can veto. Chair said he had a feeling that immigration services didn't get it right in the case of Chadha. Nixon v. GSA. Court didn't reach legislative veto here. Rules in Nixon, adjudication in Chadha. Bill of Attainder. Issue that went undecided here. Policy problems W/legislative veto. Due process. What kind of due process is Chadha going to get here? No hearing. No basis. Neither House of Congress has to give their reasoning. No judicial review. Congress had no resources to make these rulings. Constitutional issues. Legislation. If this is legislation, Congress is not following the method of legislation as provided in the Constitution. Is this legislation? Replacing a law, therefore a law. One-house vetoes. Framers knew how to write one-house vetoes and put them in Constitution when they wanted. Implementation and adjudication. Default position here is Chadha gets to stay, but the normal default of a bill is that nothing happens. Separation of powers. Want separation of power. B/C were worried about the concentration of power in one branch. Congress elected to make laws, not elected to implement the law. Adjudication. Also stepping over the line and taking the powers of the judiciary. Doesn't matter if this is legislation, B/C Congress can't implement the laws and cannot adjudicate law. No formalistic B/C court took into consideration the broad scope of the legislative veto at that time. Implied grants vs. express grants. Congressional silence. Logical inferences. How can one house inactivity have more significance than one house acting? Miscellaneous. Should President have to defend this law or other one-house vetoes? President is making a separation of powers argument. In situations like this, presidents should not have to defend laws that affect the president. Congress then has to defend the law. However, President should have to defend the law otherwise. Severability. What happens when one part of the statute is unconstitutional and another part is? Clinton v. New York, line item veto. This case v. Chadha. Differences, President and Congress are on the same side here. Similarities, both attempting to bypass the system of legislation set forth in the Constitution. Motives behind making the changes proposed. President wants to pick and choose the vetoes he wants. Congress makes compromises on both sides to pass laws, and the line item veto would undermine this. Explicit line item veto would be unconstitutional. Statute. Within 5 days. Congress can pass disapproval bill. President can veto. Congress can overturn veto with 2/3 of both houses. Reduce the budget. Not harm the national interest. President making a different policy choice than Congress is making. Essentially Youngstown. Policy choices should be made by Congress. Default option. Under line item veto act, President. Otherwise, Congress. Could Congress do this in a particular bill? Yes, but President would likely have to give up something in each negotiation. Difference between retail and wholesale. Fundamental shift of power. Congress is handicapped whenever they negotiate the budget with the President. Can President refuse to spend money prescribed in an appropriations bill? Should not construe appropriates law to require President to spend money for a purpose that no longer exists. No change in circumstances here though, only 5 days. Holding. Constitutional problem. Violates separation of powers. Chadha. Has Congress picked the wrong tool? Doesn't seem like there is a reasonable alternative. All about the power of the President. Too much power to the President. Structural limits on the government to protect the people of the country, not just Congress. Formalism, Breyer. Technically right in division theory. But this would never happen. Compromise of Congress. Jackson I category. Congress willingly surrendering/delegating their power. Doesn't matter here though. Can't waive separation of powers. It affects the public and protects them from government. Not personal rights of the President or of Congress, but rather the rights of the people. These are structural protections. 6. Congressional control over executive branch appointments. Appointments Clause, Article 2, Section 2, Clause 2. The President shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers, as they think proper, in the President alone, in the courts of law, or in the heads of departments. Would you rather win Myers or Humphreys? Easier under the statute to get rid of the employee, Humphreys. Myers is procedurally harder B/C. There is no argument for cause. Myers v. United States. Facts. Postmaster General of the First Degree, Supervisor of the Post Office, in Portland, Oregon. President probably attempting to grant a political favor. Firing executive officers. All officers can be removed through impeachment. Is this the only way to remove an officer? No. Default option. Employment at will, basic presumption, employer can fire at any time for any reason, any time, etc. absent of a contract provision. Argument against. Symmetry. Congress has to approve on the way in and they should approve on the way out. Senate removal provision. Check on the way in is a limited check on the appointment. But, should force the president to interact with someone who won't follow and promote his policy. In the case of Myers, wouldn't want to establish this precedent for more important positions, Secretary of State, cabinet members, etc. Not having someone there that you want is different from not being able to remove someone you don't want. Really about the Senate interfering with the power of the president. Similar to one House veto issue in Chadha. We should not assume framers' silence didn't mean anything. Framers were extremely careful in placing and balancing checks and balances. If president is bound on the back end to remove itself from a treaty. Not a sensible way to run the country. Humphreys Executor v. United States. Can President remove Humphrey? Policy differences. President has to have cause. Rationale. FTC is not part of the executive and therefore the President cannot fire. Weak argument. Quasi-legislative. Therefore not the same as Myers. Bottom line. Congress can't involve itself in firing. Could cause in some cases is constitutionally acceptable. Bosher v. Sinar. CBO is a part of Congress, OMB part of the executive. Delegation of power to Comptroller General. Issue, Congress can remove Comptroller General without the impeachment process. No Chadha problem because there is proper appointment. Congress has the problem to remove executive officer which is a problem. President should be able to control the people working for him, and here the Comptroller General is not accountable to the President. Although he is an agent of Congress, he is implementing the law and therefore is a part of the executive. Long history of Comptroller General being the agents of Congress rather than the agents of the executive. Additionally, only 3 nominees given to the President before he makes his choice. Harder for President to remove Comptroller General than in Myers B/C. It has to go through both branches of Congress. Officer of the United States. CBO an officer of the United States? Making a recommendation at most, no operative effect. As between the Congress and the executive. X. John Bolton, National Security Advisor. Not subject to Senate confirmation. President does not need to appoint. No binding legal authority. Officer is operative effect on third parties, someone outside of their branch. Dissent, White. Less formal view of separations of powers and checks and balances. If it's not expressly prohibited, in re to checks and balances, then it's okay. Majority doesn't the self-aggrandizing is okay. Morrison v. Olson. Goal of statute: anticipate and create a structure to fix problems surrounding Nixon's presidency. Prevent recurrence of United States v. Nixon. Constitutional problem: who will appoint the independent counsel? B/C. They are an officer of the United States. Don't want presidential appointment here. Don't want a permanent position. The independent counsel would have to constantly be investigating someone. Courts of law: appointing official in another branch, interbranch problem. Long history of Congress allowing judiciary appoint U.S. attorneys. Court uphold division of court appointing independent counsel. Inferior officers: is independent counsel inferior officer? Problematic because if the independent counselor is inferior then they cannot be fully independent. Also want the position to be inferior because then the president doesn't have to appoint. How does Congress get around this problem? Front end: files credible information to the Attorney General. AG makes a recommendation on appointment. Limited scope for investigation prescribed by the AG. If more info is found, have to go back to AG, and AG must give another recommendation. Back end: subject to firing by AG for cause. Suggests that independent counsel is subordinate of AG. Independent counsel has to follow rules and procedures of the Justice Department. Additionally, IC can't extend scope of investigation, has to go through the Justice DEPT. Compare to Humphreys and Meyer. More like Myers than Humphreys because independent counsel is clearly part of the executive branch. Not quasi-legislative or quasi-judicial. More like Humphreys because firing is for cause. Myers might have come out differently as postmaster could be fired for cause. Why is this constitutional? Doesn't violate appointments clause. Separation of powers. Valid statute. Congress signed. President who signed into law agreed. Compare to Nixon v. GSA. No congressional aggrandizement. Limitation on the power of the president. Does this impede the power of the president to carry out the functions expressly required by the Const? Yes, but not a substantial enough of a limitation to declare unconstitutional. Is this decision consistent with Judda and Bosher? Approach. First step. Here they went through the same steps to determine whether there was an express provision against this appointment. Second step. Still interference with the separation of powers. Consistent in that they look to express provisions first and then go forward and ensure further consistency with separation of powers. Dissent, Scalia. Article 2. Unitary executive theory. Executive power equals all executive power. Framers didn't use all here, and therefore didn't mean all. Inconsistent. Not purely formal. NLRBV. Noel Canning. Article 2, Section 2, Recess Appointments Clause. The President shall have the power to fill up all vacancies that may happen during the recess of the Senate, but granting commissions which shall expire at the end of their next session. Includes executive officers, but also Supreme Court justices. Lower federal courts allowed these recess appointments to go forward. Presidents used recess appointment power to get around filibusters and other delay tactics. Presidents felt like they couldn't get things done. Originally created because Congress took longer to travel. Congress was in session for a shorter part of the year. History doesn't help us determine the balance between the President and the Senate here. Filibuster v. Recess appointments. Additionally, Senate started practicing non-recess recesses. No full recess in between sessions because of this practice. The narrow interpretation. No recess interpretations because Senate can gavel in the next session immediately when the preceding session ends. Court decides on a broad interpretation of the length of recess. Executive would argue every night there was a recess. Should court be determining this? No judiciable standards. 3 days that Senate and House have to agree for recess. 10 days, out of thin air. Presumption that between 3 to 10 days is not a recess. Can be rebutted for very unusual circumstances. Bottom line. Same outcome if President would have lost the argument. Essentially no recess appointments. Happen. Does happen mean it arose when Senate was not in session? Or there was a vacancy to fill when Senate was not in session? Happen is not the same as occurred or arose. 7. The war between Congress and the President. Zivotofsky v. Kerry. Issue: does the President hold exclusive recognition power? Congress passes Statute W/2 provisions. Only first provision up for review at this time. Congress holds people can either put Jerusalem or Israel on the request of the parents. State DEPT refused to do this. Second provision attempted to put embassy in Jerusalem. President did not do this. Long history of staying neutral over the issue of who controls Jerusalem. President vs. Congress. Source of executive power: ability to receive foreign ambassadors. Recognize where the ambassadors say they are coming from. Source of congressional power: Naturalization Clause and Commerce Clause, extends to foreign commerce as well. Naturalization Clause gives power to decide who comes into the country. President doesn't challenge Congress's power here. Part 3 of Youngstown. Congress duly enacted a statute, so President needs to have some authority to bypass Congress. Supreme Court upholds President here. Exclusivity of the power of recognition. No case law though. Court cites cases that are concerned with federalism. These are not relevant here. B/C This isn't a federalism issue. Pardon power. Congress cannot impose substantive conditions on pardon power. Expressly provided for though in express language in the Constitution. Nixon v. GSA, Morrison, and this case all involve the President competing with a statute. In Nixon and Morrison, the President lost though. Express authority. Substantially impairment with the power of the President. Courts balancing interest of President and Congress. Congress can't put passport limitation on here, but can control the issue here in another way. Enact an embargo. Decline to confirm an ambassador. Declare war. Power of the purse. Impose conditions on spending. Kennedy didn't want to deal with this question. Why did President win? No good reason for Congress to do this. Not really constitutionally significant. Congress had not real reason to step in. Kennedy disavows the Justice DEPT use of Curtis right for any and everything, pg 6 of SUPP. War Powers Resolution, pg 391. When can the President use military force? No permission from Congress. Doesn't have to wait. Defensive matters. When Pres uses military force, what must he do if he engages in hostilities? Must send report to Commerce within 48 HRS, costs, how long, etc. How long? If no authorization, after 60 days, President must cease hostilities. Justiciable. Going to war. Report to Congress. Violation of separation of powers. X. Reagan didn't file report to Congress. Standing. Probably. Political question? Merits don't seem to think it's a political question. Merits. Dismissed as moot. Standing to get report, but more difficult on the other issues. Look at Nixon v. GSA. If Congress can't do this, what else can it do? Cut off funding?